Chapter 7. Consideration of Negotiable Instruments. Section 61. Meaning of term. In general, consideration means inducement to a contract, that is, the cause, motive, price or impelling influence which induces a contracting party to enter into a contract. It means the reason or material cause of a contract. That is, by consideration is meant a benefit or gain of some kind to the party making the promise, or a loss, detriment or injury of some kind to the party to whom the promise is made. Section 62. Consideration in general. The Negotiable Instruments Law provides, value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value, and is deemed such whether the instrument is payable on demand or at a future time. Valuable consideration may, in general terms, be said to consist either in some right, interest, profit or benefit, accruing to the party who makes the contract, or some forbearance, detriment, loss, responsibility, or act, or labor, or service, on the other side. And, if either of these exists, it will furnish a sufficient valuable consideration to sustain the making or endorsing of a promissory note in favor of the payee or other holder. In general, a valuable consideration as applied to the law of commercial paper is any consideration sufficient to support a simple contract. Thus a cross-acceptance, the forbearance of a debt of a third person, the compromise of a disputed liability or a debt barred by the statute of limitations, are held to constitute a valuable consideration. Where a person has a valid and subsisting right or interest in property, a waiver or release thereof is a sufficient consideration for a promissory note made to such person. If a claim is clearly illegal and unfounded and no proceedings have been instituted thereon, a note given in settlement thereof is however without consideration if there be any reasonable doubt about the validity of the claim. A compromise thereof is a sufficient consideration for a note, and in an action on such a note the invalidity of the claim compromised cannot be asserted. Ignorance of the maker's rights in respect to an alleged liability will not affect the validity of a note given on account of such liability. A note given by the treasurer of a corporation in consideration of the discharge of a disputed claim against such corporation is valid. The Negotiable Instruments Law provides, as above set out, that an antecedent or pre-existing debt will be a valuable consideration in support of a bill or note when the bill is received in absolute payment of the original debt, yet if received for nothing but a conditional payment, the holder's rights will be determined by a subsequent rule governing bills taken as collateral security. A promissory note given by the maker, in exchange for a promissory note given by the payee, is for a valuable consideration, and is in no sense an accommodation paper, although made for the mutual accommodation of the parties. A consideration founded on love and affection, as that naturally existing between husband and wife, father and son, etc., or upon gratitude, is known as a good consideration, as distinguished from a valuable consideration, and is not of itself sufficient to support the obligation of a bill or note as between the original parties thereto. A note may be given for services to be rendered, and upon the rendition of the services the consideration becomes complete and will be sufficient to sustain the validity of the note even if the services are not equal in value to the amount of the note. Services rendered out of kindness, and without expectation of reward, although of value, are not a sufficient consideration to support a note, but the consideration is not affected by the fact that the services were rendered without an express promise to pay. An agreement to marry, which is afterward fulfilled, is a sufficient consideration for a note made by the intended husband. An agreement or promise to make a gift in the future, not being based upon a valuable consideration, is not enforceable, even when put in the form of a promissory note. A mere moral obligation is not a sufficient consideration to support a promissory note between the parties to such obligation. Forbearance to prosecute a legal claim is a sufficient consideration to support a promissory note. Receiving a bill or note as security for a debt or forbearance to sue upon a present claim or debt, or the dismissal of a pending suit, or the surrender of a prior valid note, or becoming a surety, or giving an extension of time to an imputed debtor, or doing any act at the request of the drawer, endorser, or acceptor, will be sufficient consideration for a bill or note. An extension of time upon an indebtedness is sufficient consideration for a promissory note given as collateral. Therefore, a fluctuating balance may form a consideration for a bill or note, as where bills or notes are deposited as a security for the balance of an account current. The successive balances form a shifting consideration for the bill or note. But where the account has been settled or transferred prior to the execution of the note, the consideration of course fails, and the note is invalid. Section 63. The necessity of consideration. By the common law a promise made without consideration was invalid, and in order to enforce any contract, it was necessary to aver and prove a consideration. The most ancient exception to this rule was made in reference to a promise under seal, the solemn act of the party in attaching a seal to the evidence of his contract being regarded as importing or excusing a consideration and stopping him from denying it. The necessities of trade soon produced another relaxation of the rule, and by the usage and custom of merchants, bills of exchange and promissory notes came to be regarded as prima facie evidence of consideration, and peculiar qualities were accorded to them which were possessed by no other securities for debt. It is presumed that every negotiable instrument was given upon a valuable consideration, and words acknowledging receipt of consideration are not essential to the validity of the paper. If the instrument sued on is negotiable, it is unnecessary to aver or prove consideration, for it is imported and presumed from the fact that it is a negotiable instrument. But if the paper does not possess the quality of negotiability, it does not, per se, import a consideration, and it must be averred and proved, unless it be stated on its face that it was given for value received, or contains some other equivalent expression, in which case it would be prima facie evidence of consideration. As between the immediate parties to a negotiable instrument, an actual, valid and valuable consideration cannot be dispensed with. In such case the presumption as to the validity and value of the consideration only affects the proof, the burden of proof being thereby shifted from the person to whom the instrument is payable to the person who is liable thereon. In seeking to recover on a simple contract, it is a general rule that the plaintiff must allege and prove that the contract was made on a valuable consideration. But to this rule commercial paper is an exception. It would seem then that as between a promisor and a promisee of a promissory note, or the drawer and drawee of a bill of exchange, a lack of legal consideration would be a good defense in an action on such note or bill. As between immediate parties, the ordinary rules of contracts as to consideration prevail, such as that the consideration must be valuable as distinguished from merely good, that it need not be entirely adequate, and that it must not be illegal. Section 64. Presumption of consideration. Bills of exchange and promissory notes, like simple contracts under seal or executed pursuant to a statute, import a consideration. There are some decisions which hold that a non-negotiable instrument does not import a consideration unless it is so declared by statute. But the majority of cases seem to hold that a non-negotiable instrument also imports a consideration. In those jurisdictions where it has been held that these instruments import a consideration, it is unnecessary to use the words value received, if these words are included in the bill or note. The maker's or other person's right to defend on the ground of want of, failure of, or illegality of consideration is not affected. Every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. Section 65. Sufficiency of consideration. Any act of the maker from which the acceptor derives a benefit or from which the maker may sustain any detriment or inconvenience, is a sufficient consideration to support a promise. If there is no fraud in the transaction, the fact that the consideration is not equal to the obligation incurred is no defense. In such case, if the consideration is not wanting at the time the obligation is incurred and does not fail in any part thereof afterwards, it is sufficient. If that which was given as a consideration for a promissory note is worthless, it has been held that the maker cannot avail himself of it as a defense. But if the worthlessness of the thing given in consideration for the note consists in a defect of title, it may be used as a defense. Section 66. Inadequacy of consideration. It is not necessary that the consideration should be adequate to the obligation incurred in order that the parties may be bound. The only essential element in this respect is that the consideration consideration must be a valuable one. Thus in an action upon a promissory note given as the price of real or personal property, it will not avail as a defense to the note that the property conveyed was inadequate for the amount of the note. The mere fact that a bargain is hard and unreasonable will not induce even a court of equity to interfere. The law presumes that a man is capable of managing his own affairs, and the fact as to whether or not his bargains are wise or unwise is not a proper question for either a legal or equitable tribunal. While inadequacy of consideration is not of itself a sufficient ground for either legal or equitable relief, yet it may be shown as evidence of fraud. Ordinarily the mere fact of inadequacy of consideration has very little weight, when standing alone, but coupled with other elements tending to show fraud it becomes a very material factor of constructive fraud. It has been generally held that a note for a patent right which is of no value, either because it is useless or because the patent is void, is without consideration and therefore not enforceable. The fact that the vendor believed, at the time of the sale, that the patent was valid is not material. It should be noticed, in this connection, that an invention which is not useful cannot be patented, and therefore a patent for a useless invention is void. If an invention is useful, in the sense that it may be applied to some practical or beneficial purpose, it is patentable, and the degree of its utility or practical value does not affect the validity of the patent. If there is a valid patent, in this sense, the court will not inquire into the adequacy of the consideration. Section 67. Illegal, immoral and fraudulent consideration. Where the consideration is illegal in whole or in part, it is a defense against the entire note while in the hands of an immediate party or one who is not a bona fide holder for value without notice. Common law considerations are illegal which, 1. violate the rules of religion or morality, or, 2. are such as contravene public policy. Many acts in themselves immoral are made by statute illegal considerations for the support of commercial paper. A note given for future illicit cohabitation is invalid, although if it be given in consideration of past cohabitation it is enforceable. A note by a husband to his wife, upon the promise of the wife to withdraw all opposition to proceedings for divorce instituted by him, is founded upon an illegal consideration. A distinction is to be made between a consideration simply illegal and one which by statute expressly makes the bill void. In the former case a bona fide transferee may recover, though not in the latter. When the consideration for commercial paper is clearly fraudulent, it is a good defense against an immediate party or a remote party unless he is an innocent holder for value. If the instrument is yet in the hands of a party with notice, a court of law will compel its surrender, or restrain its negotiation until the question of fraud is settled. Section 68. Want or failure of consideration. Want or failure of consideration is only a defense as against an immediate party or as against a remote party who is not a holder for value. It is not a defense against a remote holder for value. As between the original parties to a bill or note, want of consideration then is a good defense. And this is so although the words for value received are contained in the instrument. This want of consideration may be total or partial. In the former case it affects the entire validity pro tanto. So also a failure of consideration is, in most jurisdictions, deemed a valid defense in an action on a note or bill. But there is more difficulty as to a partial failure of consideration. In such a case the rule seems to be that unless the facts are such that the amount to be deducted because of the partial failure can be definitely computed, or unless the amount is liquidated or in the nature of a certain debt, such partial failure of consideration will constitute no defense. There are many jurisdictions, however, where a partial failure of consideration is permitted as a valid defense, although the amount be unliquidated, and in some jurisdictions such partial failure is declared a defense by statute. It is stipulated in the negotiable instruments law that absence or failure of consideration is matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Section 69. Between whom question of consideration may be raised. As a general rule the want or failure of consideration can only be raised as between the immediate parties. This question may also be raised as to any purchaser of the instrument who takes it with notice of such want or failure of the consideration. unless he acquires title from a bona fide purchaser for value. In the case of the endorsement of an instrument, the question of consideration for the endorsement may be raised as between the endorser and endorsee. In a bill of exchange, the want or failure of consideration may be shown in an action brought by the payee against the drawer, by the endorsee against the payee, or by the drawer against the acceptor, but not in an action between the payee and acceptor. Section 70. As to accommodation paper, the following provision is found in the Negotiable Instruments Law. An accommodation party is one who has signed the instrument as maker, drawer, acceptor or endorser, without receiving value therefor, and for the purpose of lending his name to some other person. Such a person is liable on the instrument to a holder for value notwithstanding such holder at the time of taking the instrument knew him to be only an accommodation party. The mercantile credit of parties is frequently loaned to others by the signature of their names as drawer, acceptor, maker, or endorser of a bill or note, to raise money upon, or to use otherwise for their benefit. Such instruments are termed accommodation paper. An accommodation bill or note, then, is one to which the accommodation party has put his name, without consideration, for the purpose of accommodating some other party who is to use it, and is expected to pay it. Between the accommodating and accommodated parties, the consideration may be shown to be wanting, but when the instrument has passed into the hands of a third party for value, and in the usual course of business it cannot be, but if the holder has notice of defences, the accommodation party may set up any defence which would avail the party accommodated, as to set off or debt due from the holder to the party accommodated. Until an accommodation bill has been negotiated, the accommodation party may rescind his obligation and demand the recall of the instrument or the cancellation of his signature. The consideration given by a holder for value of accommodation paper makes the paper enforceable against all parties to it, and this is true even where the paper has been negotiated after due. It is a well-established rule that a promissory note given by the maker, in exchange for a promissory note given by the payee, is for a valuable consideration, and is in no sense an accommodation paper, although made for the mutual accommodation of the parties. And this is so though the note given in exchange is worthless, and it has been held that an endorsement of X's note by Y to Z is a good consideration for a note from Z to Y, and it is no defense to Z's note that he failed to recover against X on the note endorsed to him by Y.